You ready? Members of the Committee on Criminal Jurisprudence will come back into order from recess, and we need to call the roll again.
Chair Smithy?
Here?
Vice Chair Wu?
Here.
Rep Bowers?
Here.
Sorry. Representative Cook?
Here.
Representative Jones? Representative Little?
Here.
Representative Louderback?
Here.
Representative Money?
Here.
Representative Moody? Representative Rodriguez Ramos?
Yeah, present.
Representative Verdell?
Okay, a quorum is present. We've got everyone here, so we will come to order. And members, earlier in the meeting, the chair had announced that we would be voting on a couple of things. So let me, at this time, House Bill 305 by Representative Hayes. There is a substitute on that. I think y'all have been given a copy. This is the bill that was heard last week and relates to the time period for conducting a pretrial hearing after a criminal defendant has been restored to competency. As I recall, there was no real objection to that, and everybody seemed to think that was something we needed to do. And so with that, Representative Moody, will you lay out the substitute? Representative Moody lays out the committee's substitute. Is there any objection to the adoption of the substitute? There being none, the substitute is adopted, and Vice Chair Wu moves that that House Bill 305 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed and sent to the Calendars Committee. The clerk will call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers?
Aye.
Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little?
Aye.
Representative Louderback?
Aye.
Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos?
Aye.
Representative Verdell?
Aye.
So by an 11-0 vote, House Bill 305 will be reported favorably and sent to the Calendars Committee.
Do you need to say as substituted? Do you need to say as
All right, as substituted, the substitute version. And then, members, we also heard that bill this morning that was a very emotional bill from Representative Ashby dealing with the sex offender registration requirements. We just heard that this morning. Does anybody object to going ahead and voting on that now? We had told the family we'd try to do that today. So if there's no substitute on that.
Oh, no, that's right. It was renaming the bill.
Oh, it's a rename, there was a substitute renaming the bill. So Representative Wu will lay out the committee substitute. Representative Cook, well, first of all, is there any objection to the adoption of the committee substitute? There being none, the substitute is adopted. And Representative Cook moves that House Bill 2000 as substituted be reported favorably and sent to the full House with a recommendation that it do pass, and probably at the calendars at this point, I think would probably be good. So is there,
Oh, no, you're fine.
clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers?
Aye.
Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little?
Aye.
Representative Louderback?
Aye.
Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos?
Aye.
Representative Verdell?
Aye.
Okay. Thank you, members. By an 11-0 vote, the bill will, the motion is adopted. The bill will be reported favorably to the full House and sent to the Calendars Committee. Members, next week, hopefully we can vote on some other bills. If you all have any that you really want to pass, it would help if you could, let us know that you've got the votes in the committee to get it passed, that you've run it by enough members and the members are okay with the bill the way it is, and that we're ready to go on it. So, okay, I want to make clear on the record that House Bill 2000 was reported favorably as substituted. So with that, thank you all for doing those votes. And then we've got 4 more bills that we've got up today and that we didn't get to this morning. And I don't see Mr. Guillen, but let's, Mr. Cook, you want to do, well, actually, let's do Mr. Verdell. You've got time to do yours, don't you? Okay. Let me do his because Mr. Verdell's going to have to leave. So at this time, the chair would recognize Mr. Verdell to lay out and explain House Bill 2066.
This is first bill to lay out.
Thank you.
And the question was just asked whether this is your first bill layout.
I don't know.
Okay.
Yes, it is, yeah. Any commentary before I start?
Well, state your name and whether you're for or against the bill.
Thank you, Chairman. My name is State Representative Wes Verdell, and it threw me off there. I can go ahead and present, right? Is that all right? Okay. Anyways, thank you all for hearing this bill today. Today I'm here to submit House Bill 2066 for your consideration. The bill addresses a gap that was left in our expunction law following passage of HB 1927 in the 87th legislative session. If y'all remember, that was an amendment by Mrs. T. And it passed 145-0 when that amendment was presented. However, it was missing a point that we're just adding to this, to the code. The issue is that those who were placed on deferred adjudication, or let me back up real quick. The bill addresses a gap left in the expunction, also known as constitutional carry, which allowed individuals convicted of unlawful carrying a handgun prior to September 1st, 2021 to have their records completely expunged. The issue is that those who were placed on deferred adjudication for the same offense under the same circumstances were excluded from relief. In other words, Texas law currently treats those who receive deferred adjudication for unlawfully carrying worse than those who were convicted. HB 2066 fixes that inconsistency. It amends Article 55 Alpha .005 of the Code of Criminal Procedure to allow individuals who receive deferred adjudication for unlawfully carrying before September 1st, 2021 to petition for expunction provided they meet all other eligibility requirements. The bill has no significant fiscal impact to state or local governments, according to the Legislative Budget Board. Also, this legislation promotes fairness and equal treatment under the law, and for these reasons, I respectfully ask that your favorable consideration of this excellent bill, House Bill 2066, and I'm happy to take any questions.
Any questions for Mr. Verdell? Yes, Mr. Moody.
Mr. Verdell, in the past, you've presented yourself to testify against many of my bills.
That is true.
So I have a number of questions about the complexities of expunction law, and I'd like for you. I actually appreciate it. This is another one that I'm sure Representative Little will love. That a gap in the law that made no sense. We're coming back to figure it out. Great bill. I was trying to figure out a way to vote against it, but I can't because it makes sense.
Appreciate that.
So no, I appreciate it, and I think this is good. I think we do need to look at some of those other. We've had a series of weapons charges that we have taken off the books, switchblades, knuckles, things like that.
Yeah.
And so I think those are the types of things that we should permit people to go back and clear up their records
Yeah, I agree.
under those circumstances. So this is a piece of that puzzle, and I appreciate you doing that. Thank you.
Thank you, Rep. Moody. Appreciate
Ms.
that.
Bowers.
Thank you, Representative Wes Verdell. I like to say your whole name, you know that. I think
good sounding
you
name.
said it. Yeah, it actually is, but I think you said it makes you remember something or another. But I do have at least one question. How would you address concerns from those who might view your bill as weakening our stance on firearms offenses?
So I don't think it actually weakens it. What this bill is basically doing is, and that amendment that had passed in the constitutional carry was a great amendment. Basically, it was a great amendment because it allowed those who had been charged with the unlawful carry before 21 to have the chance to expunge it. But unfortunately, it left out those who had been placed on deferred adjudication. So we're just basically treating those on deferred adjudication the same way that we already treat those who had that unlawful carry prior to 21.
Thank you so much. And like Mr. Moody said, you've been before us many times.
Yes,
so
ma'am. I enjoyed it.
we appreciate having you back in this capacity. And I will certainly look to see if I have further questions for you. None right now that I can see, but thank you for bringing this piece of legislation.
Thank you, Representative Bowers. Appreciate it.
I've got Ms. Jones has a question.
I just wanted to say for anybody who thinks it's soft or something, or in a deferred adjudication, there literally is no finding of guilt,
Yes, ma'am.
as long as you do what you're supposed to do. And if someone asks you if you have a conviction for something, you can say, no, I haven't. So I see that that's distinguishable, which is why I think it's okay.
Thank you, Representative Jones.
Okay, any other questions? Okay,
With that, I'd just like to reserve to close.
Okay, we'll do that, so.
Thank you, Chairman.
Okay, we've got Paige Williams here.
Good afternoon, Chairman. My name is Paige Williams. I'm here representing Dallas County Criminal District Attorney John Crusoe. We are in support of this bill. This is kind of a pet peeve of mine because some of y'all know me as an appellate attorney, which is my day job, but I also do expunctions in the Dallas office. And this is a loophole that was created during constitutional carry, and it's just allowing us to expunge a deferred adjudication for a law that has been repealed, essentially. And if you have any questions, I'll be more than happy to answer them about expunctions and the UCW.
Any questions for Ms. Williams? Thank you
Thank you.
for being here. Is there anyone else here to testify for, against, or on House Bill 2066? If not, Representative Riddell, if you want to close.
Wait,
Ms. Bauer.
Yes, ma'am.
Mr. Verdell, so are you cleaning up something that you created almost?
No, but it's this was an amendment that was I still remember watching Ms. T present this amendment, and nobody was expecting this amendment from what I knew, and I heard her say it, and I was like, that is an excellent amendment, and like I said, it passed 145 to 0. The only reason it wasn't 150 is one, because your speaker and 4 absentee votes or absentee
Absolutely.
members.
I remember. Thank you so very much.
Thank you, appreciate it.
Thank you. Anything else? Okay.
No, members, I appreciate y'all's time. I'm honored to be here with y'all. I think it's very clear, very simple. I think it's an excellent bill, and I really appreciate y'all taking the time to listen and ask questions. I expected more first-time harassment questions, but I didn't get any of those. So any of them yet? No. Okay, there we go.
Ms. Jones. I
Actually,
think.
no, it's going to happen on the floor when you, no, it's going to happen on the House floor.
Okay, I'm ready for it.
That's when it's going to happen.
Don't ever ask for more. Okay.
I like punishment.
Bowers?
Yeah.
Yes, I was gonna say, Mr. Chairman, thank you, but are you a glutton for punishment? And
Yes.
I see, and you're here, right. But at any rate, if Dallas County is for it, then I'm for it.
Awesome, thank you. Thank y'all for y'all's time. I appreciate it. With that, I close.
Okay, thank you, Mr. Riddell. And so if there's no objection, we'll leave House Bill 2066 pending, and hopefully we can get it out next week, and shouldn't be too much controversy, I wouldn't think. Thanks. Is it okay if Ryan goes? Okay. Mr. Guillen, you ready? Okay. Mr. Guillen, which one would you prefer to do first? You've got 2 up on it.
Either one, just go with the lower numbers, fine.
Okay, well, the chair would lay out House Bill 207 and recognize Representative Guillen.
Thank you, Mr. Chairman. Members, last session, the legislature took an important step to protect children by passing House Bill 2700. That bill, which passed this committee unanimously in both chambers overwhelmingly and was signed into law by the governor, created a new offense for the possession, promotion, or creation of sexually explicit visual material that depicts children. But late in the process, a stakeholder approached us with concern. While HB 2700 addressed images, videos, and other forms of visual material, it didn't include sexually explicit visual depictions involving anatomically correct dolls, mannequins, or robots that are made to look like children. HB 207 is a simple but necessary fix. It expands the definition of visual material in statute to include any printed or reproduced image or likeness on an anatomically correct doll, mannequin, or robot that has the features of a child that is intended for sexual stimulation. The purpose is clear. Just as we do not tolerate the visual depiction of child exploitation in digital or photographic form, we shouldn't permit it through physical representations that serve the same purpose. This bill ensures that individuals who attempt to simulate or normalize sexual abuse of children through lifelike representations are treated the same under the law as those who use digital or computer-generated images. HB 207 closes an unintentional gap in existing law and reaffirms our commitment to protecting children from exploitation in all forms. I've talked to Representative Little and others about strengthening the language on the bill to better ensure the effectiveness of it. So I'll be working on a committee sub with them, and we'll get it back to y'all as soon as possible. Happy to answer any questions.
Any questions for Mr. Guillen? Okay, we've got a witness, so we'll, Chair calls Deborah, and we'll reserve the right to close. Deborah Simmons. Thank you.
My name is Deborah Simmons, and I'm testifying neutral on HB 207. Thank you to Chairman Guillen for your consistent commitment to fighting sex crimes and to this committee for your time and consideration. In a Texas town, law enforcement seized over 200 images of child pornography and arrested a man for possession. He was also found in possession of a childlike sex doll. However, this abhorrent behavior was not documented or nor recorded as a statistic because the possession of such a doll is not a crime in Texas. Texas should prohibit the possession, sale, and distribution of childlike sex dolls, which are obscene, anatomically correct dolls, mannequins, or robots that are used for sexual stimulation or gratification and that have the features of or have features that resemble those of a minor. Childlike sex dolls enable predators to practice subduing a child, overcoming resistance, and raping a child using realistic prepubescent dolls that may be warm to the human touch and make sexual noises and sounds. Dolls are customizable to include accessories and equipped with settings to change facial features and expressions. One investigative report from another state described the parts included a silicone lower torso of a childlike sex doll, items of infant clothing, and a flesh-like apparatus consistent with the childlike appearance. A mother in Boca Raton discovered a sex doll made in the likeness of her 8-year-old daughter for sale on the internet in 2020. Similar legislation has been filed previously in Kentucky, Massachusetts, and New Jersey. Utah, Tennessee, Florida, and Wisconsin currently prohibit childlike sex dolls. In 2018, the U.S. House of Representatives unanimously passed the Creeper Act, described adequately as curbing realistic, exploitative electronic pedophilic robots act of 2017 that would have prevented the sale and distribution of childlike sex dolls nationally. Sex crimes against children must not be tolerated, and any device or visual material that normalizes pedophilic behaviors and attempting to shift society's norms to make pedophilia socially acceptable must be prohibited. Should normalizing pedophilia only be a crime if we recognize the child's face? Please make sure that the language of the bill fulfills the intent to criminalize the possession and promotion of all childlike sex dolls, regardless of whether the doll is recognizable as an actual child or imagery of a child. And perhaps we should provide civil liability for the use of an actual child's image. Thank you.
Thank you very much. Ms. Jones?
What is the definition of a childlike sex toy? I know that there are dolls. I go buy dolls for my granddaughter at the store. How do you know when a doll becomes a sex doll? I'm confused about that because I don't
Right.
want, like some parents. I'll use my mother for an example. When I was younger, my mother thought it was important that I know body parts,
Sure.
right? It's, so I could know what people could touch and what they couldn't touch and what they looked like and what their function was. My mother taught me that, not for a sexual reason, but actually to, I guess, try to protect me.
Sure.
So what happens if you have that? I guess that's what I'm concerned about.
Yeah, the definition that I have here is obscene, anatomically correct doll, mannequin, or robot that has the features of a child and that is intended to be used for sexual stimulation or gratification. That is not in this bill.
How do you know if something is intended for sexual gratification? I mean, I could see somebody going to go buy a Barbie right now and trying to do something with it, right? Is a Barbie anatomically correct? I mean, you see what that's what I'm confused about. It just sort of seems ambiguous or vague or something. So how do you know?
It could be. I'm just
Oh, you're just a,
I'm just a citizen.
Okay, all right.
Sorry.
Okay, I'm sorry. I'll ask the bill's author.
Thank you.
Okay, any other questions? Thank you for being here. I need to clarify one thing. You registered neutral on
I
the bill?
did,
Is
yes.
that your position on the
It
bill?
is the position, yes.
Okay, thank you
yes.
very much.
I'm for the intent, but
Yes.
yes.
Okay,
I'm registering
thank
neutral
you.
today. Thank you.
Anyone else here to testify for, against, or on House Bill 207? If not, Representative Guillen, you want to close?
Thank you, Mr. Chairman.
Can I ask one question about this bill that's not, it's not really for you, but it's something I have a little bit of concern about. In reading more bills about AI-generated pornography in the last few days than I ever have in my life, sometimes it uses the word real and sometimes it uses the word actual. So for example, this says who's recognizable as an actual person, but some of the bills say real person. It looked like to me that actual person is the likeness of a real human being that is known, because it says actual person by the person's face, likeness, or other distinguishing characteristics such as a unique birthmark or other recognizable feature. That would be like, not that looks like a person, but that looks like that person to me. And I want to make sure that if we're, I appreciate what we're trying to address here, but if we're working on a committee substitute anyway, explore that with some attorneys and make sure that this covers any sex doll that looks like a child, even if it doesn't look like that child. I think that's even kind of peripheral to your bill, because I think it's the language that's already in that code, but I want to make sure that it's, that's covered.
Will do. If there's, y'all have any other questions? No?
Mr. Little?
Thank you, Chairman. Representative Guillen, this is, obviously something that is going to be new to all of us. And I am thankful to realize that I don't know a lot about the topic at hand. I was listening to Ms. Simmons testify and I'm shocked at what exists. I have some concerns about your bill. I spent a lot of time with this bill last night trying to make sense of this technological novelty that is abhorrent that we need to get rid of. Here's the first problem. So the bill was written into 4326 of the Penal Code, which is possession or promotion of child pornography. And I actually didn't realize this until today, but in section A1, so this is everything that possession or promotion of child pornography relates to. It says a person commits an offense if the person knowingly or intentionally possesses or knowingly or intentionally accesses with intent to view visual material that visually depicts a child younger than 18 years of age at the time the image of the child was made, who is engaging in sexual conduct. And I've highlighted in orange that provision, who is engaging in sexual conduct. And it's very easy for us to understand that in child pornography, there are images or video that reflect children engaged in sexual conduct. A doll, an inanimate object, is not, by definition, engaged in sexual conduct. So I don't think your bill will actually outlaw the existence of these dolls, because if this bill were all we passed and you bust a child pornographer and he's got one of these dolls in the house, they go, oh, you got one of the dolls under Ryan Guillen's bill, this is now a criminal offense. He's going to say, that child's not engaged, that doll's not a visual material that's engaged in sexual conduct. So this is like the supreme technicality that I think is going to screw up the entire purpose of the bill. The other problem I had with it is Representative Money touched on. It's the definition that you change. So it's in lowercase I, 4326 lowercase I. Right now, because the child pornography section of the code was written in a time when we were trying to criminalize pictures and videos of actual human being children engaged in sexual activity. The only way that this doll could be criminalized is if it were based on an actual person. You look at the doll and go, that's Susan Johnson who lives in Cleburne, Texas. That's her face. That's under section 4326I1. And then 4326I2 is what I'll call a derivative work. That is Susan Johnson's face that has been manipulated and placed on a doll. And in the language of your bill, printed or reproduced on an anatomically correct doll. And I'm not sure that the words printed or reproduced are appropriate there, because if you've got a doll, I'm assuming, out of my ignorance, that someone is shaping the face of this thing into some ungodly image, and it may not necessarily be printed on or reproduced. So, having said all that, I think there are three really good bills, yours being one of them, that address the issue. Representative Schatzline filed House Bill 1443, which I believe Chairman Smithy referred to the subcommittee this morning, which creates a new offense for promotion of a childlike sex doll. I'm not sure his language is perfect either, because we're doing a new thing here. And to Representative Jones's point, how do you know what the intent of a doll is? And I mean, in some ways you could look at the packaging and the marketing and say this is what it's for. Duh, it's obviously for sexual gratification. But the third bill is from Representative Schaffner. It's House Bill 1717. My larger concern is, going back to what Representative Money said, that this is no one's face on this doll, that it's just something a computer dreamed up. It's not Susan Johnson or based on Susan Johnson from Cleburne, Texas. It's just an image of a child that a computer dreamed up. All versions of this are equally horrific in my mind. I just want to make sure that whatever we pass is designed to capture each situation. Does that make sense?
Absolutely. Yeah.
So,
a lot of what you talked about is what we passed last session, and going in and addressing it. I would just point out that, you know, we're limited to the scope of this bill, and we could probably take care of most of those things. I'm not sure we can take care of everything in this bill, because we're limited to the scope of and germaneness to this bill. So I'll also, we'll work with you on it. We'll look at the other bills to see if we can, if there's something that doesn't fit into this one, that maybe there's some other vehicles, and if not, we'll have to come back next time. But
yeah, I'm committed to help however I can. Thank you.
Technically, we could do whatever we want, even if it's outside the bounds of the bill, but then it's subject to a point.
Any other questions? Ms. Jones?
Yeah, I'm willing to try to help you. I just need for it to be narrowly construed so that when somebody, I mean, reasonable doubt is a beautiful thing for a criminal defense lawyer, especially if the person is a turd, like seriously. And if you write a bill where you can do that, then you're gonna create reasonable doubt, and then a really bad person's gonna get away because we didn't write a bill like more focused.
We'll do our best to address both ends. Yes.
Ms. Bowers?
Thank you so much, Chairman, for recognizing me. And with all due respect to you, Chairman Guillen, I do have a couple of questions. That one, given the global nature of the internet, how effective do you believe that this state-level legislation will be in addressing consent that may be created, hosted, or distributed from outside of Texas, or even outside of the United States?
Like how effective it would be in addressing things that come from
Other
outside of
places.
Texas?
Yes, outside of Texas and even outside of the U.S.
Well, but but then would land here.
Correct.
Would be in Texas, right? Yeah, and I don't see why it would matter where it originated from.
It would
I think
still apply, you
It would
said.
still apply, yes,
Okay,
absolutely.
great. Secondly, as technology evolves, we may need to revisit the statute. Do you think there's a need for a periodic review mechanism to ensure our laws keep pace and with technological developments in this area?
Absolutely. I mean, it's just like, we passed 2,700 last time. My esteemed colleagues have found, potential issues just right now and in what we did last time. So there's always a need to reevaluate, and that's primarily where I get most of my bill ideas from is, you've got statute, and then something happens and something went wrong with what's in statute, and we try to address it. So just like that's how this bill came about. The previous witness came to me, talked to us about this particular situation. We were way far along in the process last time with our bill, and we weren't able to address it. But I told her we'd come back next time and try to address it, and that's what we're doing.
Good. Again, thank you. And I, like you and I have seen before, we have legislation that we are sorry we have to have. But thank you so much for bringing it to us. Thank you.
Thank you.
Anything else, members? Okay. So if there's nothing else, we appreciate Mr. Guillen and the chair. If there's no objection, the chair would leave House Bill 207 pending for now. And so, Mr. Guillen will do your next one. And so the chair lays out House Bill 235 by Representative Guillen and recognizes Representative Guillen to explain the bill.
Thank you, Mr. Chairman. House Bill 235, which last session passed this committee unanimously and the House overwhelmingly as House Bill 1896, but got to the Senate too late, addresses revenge porn, also known as non-consensual pornography. It's the act of distributing sexually explicit images or videos of a person without their consent. This can happen in several ways, such as a jilted ex-partner sharing intimate images of their former partner online or through social media, or a hacker gaining access to someone's private images and sharing them without permission. The consequences of revenge porn can be devastating for the victims involved. It can lead to humiliation and shame and a sense of violation of privacy. In some cases, it can even lead to loss of employment or professional opportunities, damage to personal relationships, and in extreme cases, even threats to personal safety. Moreover, the advent of artificial intelligence and deepfake technology has added a new dimension to the problem of revenge porn. These technologies can be used to create highly realistic and convincing fake images and videos of individuals that can be used for malicious purposes. The threat of artificial intelligence revenge porn is significant, as it can be used to create fake images and videos that are virtually indistinguishable from real ones. This means that victims of revenge porn may have to defend themselves against fake material that is extremely convincing, making it even more difficult for them to clear their name and restore their reputation. This bill would add revenge porn that is created by artificial intelligence to the existing revenge porn criminal and civil liability statutes. This bill is essential in addressing the threat of artificial intelligence revenge porn by acknowledging the role of computer-generated visual material in producing intimate visual material and prohibiting its wrongful use. We can send a clear message that these actions will not be tolerated in our society. We need to ensure that our laws keep up with the ever-evolving nature of technology and protect individuals from the harm caused by these nefarious actors. I can answer any questions if y'all have any.
Any questions for Mr. Guillen? Okay. Mr. Little?
Thank you, Chairman Smithy. Representative Guillen, correct me if I'm wrong, this bill is designed to criminalize the use of deep fake images, correct? Isn't it? Isn't that what it is?
Right.
Okay. And I only asked because we had Representative Gonzalez's bill earlier this morning adding deepfake images to 21-165, and I think you're trying to do the same thing just at 21-16. And so, just to be clear, what is sought to be criminalized here is derivative fake images of other people, right?
Right.
Isn't that, okay. Just wanted to make sure. Thank you.
Any other questions? Okay, if not, I'll go ahead and call witnesses. We'll
Thank you.
reserve for you the right to close.
Thank you.
Chair calls Adrian Shelley.
Thank you, Mr. Chairman. Members, Adrian Shelley with Public Citizen speaking in support of House Bill 235. I want to thank Chairman again for bringing the bill. Got some familiar written testimony going out here. I'll be very brief. We're supportive, as the Chairman explained. The bill adds civil and criminal liability for the use of AI to create deepfake materials. Representative Little, to answer your question, it's slightly different than what was done with House Bill 449. House Bill 449 was adding still images to a definition that already included videos. This bill, House Bill 235, is adding any sort of AI-produced deepfake material to both the civil and criminal liability statutes. So it is identical in that respect to the other bill that we heard, House Bill 1121. Three of the things that bill does are done in this bill, but it is slightly different than that House Bill 449, and we are supportive. Thank you.
So I think one of the concerns of the committee might be to make sure that we have a concise and consistent law here where someone can, whether it's a lawyer or an individual, can read the code and know what conduct's legal and what conduct's not legal. And when you have several sections that deal with essentially the same act, it creates a bit of an issue. So we're just going to have to figure out how to deal with that, I guess.
May I?
Yeah, Mr. Little.
Thank you, Chairman. So, Mr. Shelley, I think I understood your response, but let me start with what I think I understand. Representative Guillen's bill, I understand that there is a modification of the Civil Practice and Remedies Code, the civil remedy, which is not our primary concern in this committee, but it is important. So why would we put deepfake prohibitions or deepfake crimes within 2116 when we just passed 21-165? Like, isn't that a more natural place to put this? Do you have an opinion on that?
I think there's probably a need for both, and I've got to confess I'm not an expert in this area of code, but I think they're doing something slightly different. In that previous bill, 449, it was specifically about adding still images to a definition that at present only includes videos. What we're doing here in Penal Code 21.16 is adding to the crime of unlawful disclosure or promotion specifically AI deepfake images, that being images of an identifiable actual person that were made from their likeness.
Okay. Do we, does this bill address works? I don't know how to ask that question. Let me back up and start over. This is designed to criminalize the use of someone's likeness in a way that does not accurately represent them sexually, right? It's the use of a real person's image that's been manipulated, image or video or audio for that matter, and that is being manipulated for a wrongful sexual purpose. Is that right?
Well, it does say image, so I'm not sure if audio would be captured, but there's going to be two elements, right? You've got the fact that a person's image was used in creating the material, and then you've got that the resulting content is recognizable as an individual.
Okay. Thank you.
Ms. Jones?
As we're trying to figure this out, and I mean, I know it's not your bill, but this is like reasonable doubt sitting around this dais right now. And so I'm trying to figure out like what the crime is, right? And then I'm also thrown off because this is creme jure and we're talking about this, I think the Civil Practice and Remedies Code. So like that's confusing me too. I know what we're trying to do, but we gotta figure out a way to make it cleaner, because if we can't all, or the majority of us can't, I just think that's reasonable doubt right there. So I guess I should talk to the bill's author.
And if I may briefly, so there is that civil tort provision that's expanded, right? But I think, again, the focus of this committee is the crime at Penal Code 21.16, unlawful disclosure or promotion of intimate visual materials.
Yeah, so,
then-
I'm sorry, Judge.
And then, I mean, I think I agree with you that it says visual. Does that mean audio isn't? I mean, if somebody's moaning and groaning. So I just,
So that's a
Just
fair
gonna-
question, if I may, right? The recognizable as an individual person says, or other distinguishing characteristics. So if somebody's voice makes them recognizable, certainly I think you would fall under this statute, right? Although it does say in sub 2 there whose image was used. Still, I think recognizable by voice probably going to get you under the sub 1.
but I still think that if we use specificity with one, then most times that necessarily excludes whatever's not in there. If we start sort of like Rep. Little's example with that other bill, which I can't remember the number of, where it was better to say including but not limited to. Because if we identify something specifically, then we presume that's the bad behavior and it doesn't leave room for other stuff. I don't know if I'm explaining that.
Here's my problem with it, Representative Jones. Like, I think we have a good bill idea between Representative Gonzalez and Representative Guillen to change the law in a very effective way. Public Citizens one-pager is identical for both bills. And so
Yes, sir.
I'm just trying to figure out what's the best place to put this and why, so.
And if I may, sir, I will note that there is in that, and I'm sorry to get into other legislation, but in that House Bill 1121, there was also that addition of joint and several liability, right?
Right.
So there is that element as well.
Right, thank you.
Any other questions? Thank you for being here, Mr. Shelley.
sir.
Is there anyone else here to testify for, against, or on House Bill 235? If not, Representative Guillen to close.
Thank you, Mr. Chairman. Yes.
Ms. Bowers?
Yes, sir.
Was it for Mr. Guillen, or?
Yes, sir.
Okay, good.
Yes, I was waiting for the author to come back up. I think some of my questions still deal with technology. One with law enforcement agencies. And, did you undertake any conversations with law enforcement agencies to ensure that they would have the technical capabilities and resources to effectively investigate and prosecute these new offenses?
Well, we have talked some to them, but that's certainly kind of another facet of this whole thing that, of course, we're not addressing here.
Sure.
No.
And I just remember Representative Louderback in a different time when he was Sheriff Louderback, and he came before us in Homeland and said to us, maybe prior to the time you were Chair of Homeland, but that they don't like unfunded mandates. So I'm just trying to make sure that you've consulted with agencies to see that they'll have the proper resources.
We'll make sure we do.
Okay.
And I can see what, the line of questioning about, the difference between that other bill and this and what we're doing. I'll make sure that we all coordinate. We'll get with that bill author as well and see, and with the committee and see how best y'all want to go forward. That'd be fine with me too.
Could I ask you, Mr. Chairman, what about Meta, Google, and Microsoft, like technology companies? Have you consulted or did you with any of those?
No.
Okay.
No, I didn't.
I mean, reason being is, technology it evolves constantly. So just wanting to make sure that there, might not be any AI, there would be AI safeguards to ensure that the definitions in the bill would remain relevant.
Absolutely.
Thank you.
All right.
Anything else? Thank you very much, Mr.
Thank
Gill.
you.
And so if
Appreciate it.
there's nothing else on House Bill 25, if there's no objection, the House will leave, the committee will leave House Bill 235 pending. Members, that brings us, I believe, to the end of our bills. Anybody else have any business to come before the committee? Oh, Mr. Cook, I didn't mean to exclude you. Okay. Just kidding. No. That was just. So at this time, the chair would recognize Mr. Cook to lay out and explain House Bill 1977. I
Thank you, Mr.
apologize, Mr. Cook.
No problem
I did
at all,
not
sir.
mean to
Thank you,
exclude
Mr. Chairman, members. I do have a resource witness. I'll start with that. This bill was brought to us by the Tarrant County District Attorney's Office, and I do have a representative of the Tarrant County DA's office here, and is available for questions. But this bill is similar to some of the discussion we had earlier, deals with when certain evidence can be offered. And as we discussed earlier, for sexual and assaultive crimes against children, prosecutors may offer evidence of other crimes and bad acts committed against the child victim, as well as sexual offenses against other children in the first phase of the trial. And so what this bill does is amends Article 38.37 and adds in subdivision 3 that simply says that if the action is committed against a person of any age with regard to sexual assault under section 22.011 or under aggravated sexual assault, which is section 22.021 of the Penal Code. So if one of those two offenses are against a person of any age, as opposed to limiting it to against a child, then acts of bad acts or prior crimes or bad acts can be offered in the open part of the case. Be glad to answer any questions. Otherwise, I'd like an opportunity to close when appropriate.
Any questions for Chair Cook? Okay, thank you. We'll certainly recognize you to close. Chair calls Lauren Lawrence.
Thank you, Chairman Smithy. Members, my name is Lauren Lawrence. I am a felony prosecutor with the Tarrant County Criminal District Attorney's Office. I am here on behalf of Phil Sorrells, happy to testify as a resource witness, but I did register in favor of the bill. As Representative Cook mentioned, this was something that our office brought to him as something we are interested in seeing pass. So happy to answer any questions that you all have.
And we apologize for you having to wait as long as you did to the end of the program.
Not a
and
problem.
the other witnesses as well.
That's what we're here for.
Any questions from Ms. Lawrence? Ms. Jones? Yep.
So, child is scratched out throughout, is redacted or scratched out. What is this bill intending to do?
This bill is intending to give us the same opportunity under 3837 for adult victims of sexual assault and aggravated sexual assault to offer extraneous evidence of sexual bad acts by this defendant, as we have in child sexual abuse cases.
Let me digest that. Let me just digest that. I may come back.
Absolutely.
Anyone else? Mr. Little?
ADA Lawrence, thank you for being here and thank you for your testimony. You and I visited about this in my office, and I'm still formulating my thoughts around this. I mean, traditionally, you don't offer other bad acts evidence under the rules of evidence unless it's to establish some type of pattern, you know. And there seems to be a movement, a philosophical movement in Texas toward expansion of using extraneous offenses and building it into the Code of Criminal Procedure. I honestly don't know how I feel about this yet. I think generally I'm opposed to the idea of expanding it because the prejudicial weight of an extraneous offense when you're trying someone for a crime can be overwhelming. If you had someone who was on trial for rape, I mean, being under this bill, you'd be able to go back and talk about what that person did in high school or college 10 or 20 years ago. I mean, isn't that true?
If the acts that you are referring to are other sexually violent acts, yes, we cannot use this provision does not let us introduce evidence of every bad thing the defendant has ever done.
Certainly.
Under Section 1, it allows us to enter this sort of evidence specifically to provide context to the jury regarding the state of mind of the victim and the defendant, and also to provide context to the jury regarding the nature of the relationship of the parties. Now, under Section 2, it allows us to introduce extraneous bad acts of the defendant to show character conformity, which would be that pattern that you were talking about. And I did hear you ask that question earlier regarding a pattern of behavior, and we know that that pattern exists in kid cases, which is why this was 3837 was offered by this body in the first place. When I spoke with a prosecutor in my office who was in our adult sexual assault unit for several years, and asked her, can you just give me some examples of times when this expansion would have been beneficial to you in your practice? One of the examples that she gave me was a defendant that she had who violently raped his intimate partner. And what the DA's office found out through the course of the investigation of that case was that that man had violently raped every intimate partner he had ever had. And that evidence would not be currently admissible without this expansion of 3837. She also had a defendant who raped his sister. And during the course of the investigation, what they learned was that he had also raped his other sister several years prior to that. Because the second sister was an adult when the rape occurred, the evidence of the previous rape with the other sister would not be necessarily admissible without this expansion of 3837. We would be in a situation where we would have to wait for the defense attorney to ask a question that would open the door to that. And if you've got a good defense attorney, you know that's not going to happen, right? And so there are patterns in adult sexual assault cases the same way that there are in child cases. And so, it is to show conformity with that pattern character, and additionally to address concerns, because I'm sure a portion of your concern regards due process, right? There's a reason that we otherwise have 404 and we don't allow extraneous evidence unless we're using it for something else other than to show character conformity. But when we offer this evidence under Section 2, we are required to have a hearing outside the presence of the jury in which the judge makes a determination about whether the evidence that we have could be believed by a jury beyond a reasonable doubt, and that they are also instructed in the jury charge to only consider that evidence if they believe that beyond a reasonable doubt. So there are, within 3837, due process protections built in to make sure that this evidence is in fact credible before we ever put it in front of a jury. But then we also instruct them that they have to believe it beyond a reasonable doubt before they can use it in their consideration.
Let me drill down on that a little bit. What I'm hearing you say, and I don't know if this is true or not, what I'm hearing you say is if Bob is being tried for raping woman A, and women B and C say, he raped me too, Your intent is to use that evidence to convict him of raping victim A, but you need to basically conduct a mini trial with the judge and obtain a finding from the court that there is no reasonable doubt that he also raped victims B and C.
So
Did I say that correctly?
basically, yes. It's not a mini trial, but it is a hearing outside the presence, and it's in Section 2A, which is not included in the bill that Legislative Council gave us in 1977. So that's why I wanted to bring it up, because it says that before that Section 2 evidence, that conformity evidence that we're talking about, can be introduced, a trial judge must determine that the evidence likely to be admitted at trial will be adequate to support a finding by the jury that the defendant committed the separate offense beyond a reasonable doubt, and conduct a hearing outside the presence of the jury for that purpose.
Does it happen during the course of the trial, prior to trial,
That is typically left
handled
up.
in pretrial?
That is typically left up to the judge. Some judges do like to have a hearing several days before the trial starts. In my practice, what I've experienced is we will impanel a jury, and then we will have any necessary hearings kind of in that break, whether that's we send them home for the afternoon, we have all of our necessary hearings, and then we come back and do opening, because we certainly want to know what is potentially going to come in and what is not prior to doing our opening statements. So it's typically done by most of our criminal district judges in Tarrant County between the voir dire process and opening statement.
So I'm holding these two ideas in tension, that on one end of the spectrum, it's very clear that people who are sexually abusive are typically do so in a pattern.
That's correct.
That they have multiple victims. It's especially true with child sexual abuse. The other item that I'm holding in tension is it's very difficult for someone to feel like they got a fair trial if they're being accused of raping victim A, and victim B and C, who have never talked to a police officer, never reported having been assaulted, never having filled out a police report, are going to show up in the trial and say, he raped me too. It becomes so incredibly prejudicial. That's why 404 exists. And so I'm struggling holding these ideas in tension. Maybe you can help me resolve them.
Well, those are fair considerations, right? And I don't want to tell you that evidence is not prejudicial. Every piece of evidence I put on in a trial is prejudicial to the defendant, right? It's the whole purpose of it.
Yes, ma'am.
But those were considerations that this body took, those exact same considerations were considerations that this body took into consideration when implementing 3837 in the first place for child sexual abuse cases. And so what we see is that the nature of this conduct, the nature of this type of perpetrator is one that is not just going to commit, a whole bunch of crime all the time, but is specifically going to commit this type of crime. And what we also see is many times when we talk to these additional victims, is that they will tell us things where we have victim A that you were talking about will say the defendant said something to me, right? Some sort of, inappropriate comment.
Repeated MO.
Correct.
Okay.
And that what we'll find is victims B and C, he said the same thing. He asked me to do the same thing. He took me to the same place, right? And so that is corroboration for victim A, certainly, but goes to what we're talking about, right, which is something that's already taken into consideration under 404, which is the fact that it's the same type of MO, right? It's the same type of motive, it's the same type of intent, that sort of thing.
Is it true that you can use this information in a punishment phase of a trial already?
That's correct, yes.
But you want to take the information and use it in the guilt-innocence phase as well?
That is correct. That is what 3837 allows us to do. And one other consideration I wanted to add, I knew there was one more thing as far as a due process concern, and holding those two things as you were talking about, is that we also have to give 30 days notice of this information. If we are going to use it, we have to give written notice of who that victim is and what that victim's statement is, what we intend that evidence to show, so that the defendant is well on notice that these people exist and what their testimony would be, so that when we do conduct that hearing outside the presence of the jury, they've had at very least 30 days to prepare for cross-examination of that victim.
Does, in your view of the world where this bill passes and becomes law, does the defendant get to put on evidence of all his or her other relationships where he or she was not assaultive?
I don't imagine that would happen, but this bill does not consider that, to answer your question.
Okay. Okay. Thank you for answering my questions very much.
Absolutely.
Ms. Jones, do you have some more?
Yes, I do. So I've got concerns because there's already a mechanism for you to do that in guilt, innocence, if you go look under, again, 404B says that you normally don't admit extraneous offenses, right? But they can be admitted in guilt, innocence if they're relevant to something other than character, such as motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake or accident, contextual background. Again, you give notice, so there's no need to make a whole nother law. I'm not done yet, please. Also, I understand why you may modify the law for children because they're a special class of people. And this principle is why the United States was founded, because the government has all the resources. And I'm absolutely certain, based on my experience as a defense lawyer, that a hearing is like a full vetting, like a trial, right? If a defendant, and the Constitution says this, if a defendant has convictions for whatever, right, and he doesn't testify because he has a right to remain silent, and the defendant is already convicted of something else, right? If the defendant doesn't testify, the Constitution protects that you can't bring in those previous convictions, like during guilt innocence. And so an extraneous may or may not be a trial that's already been fully vetted by a jury. So I am extremely concerned that the balancing test under 403 is going to be absolutely prejudicial. And hearings are not trials. And I think I heard you say, or somebody say, that the hearing was a hearing beyond a reasonable doubt. And I would respectfully submit to you that in a trial, I'm gonna have time to go investigate. 30 days is not always enough time to be able to go find things out. And I don't think we should, because of, again, I see this a lot, and it's one reason why I actually asked to sit on crim during this session and I wasn't on it the last session, was because some bills got out and I was like, dude, how'd that get out? You know, why are we voting on this? Because as a person who's in the court almost every day when I'm not here, there's an effort that every time that we always pass bill or try to pass bills based on like the worst case scenario. So I can't say that everybody who rapes somebody has raped other people, right? So I'm struggling with undoing constitutional protections when there's absolutely a way for you to get it in guilt and innocence that doesn't have you change this.
So I would disagree that there is absolutely a way in which this evidence comes in during guilt innocence. There is absolutely a way in which it can come in during guilt innocence, but that is not a guarantee. In the case that I was mentioning earlier regarding the defendant who raped his sister, the There was no other route for that evidence to come in under 404 unless the defense attorney asked a question on cross-examination to the victim that would have opened the door to that testimony. And that was a good defense attorney. So guess what he did? He didn't ask a single question. And so the door wasn't open. And so that evidence could not come in under 404. Whereas under the expansion of 3837 in Representative Cook's bill, that evidence would have been able to come in. So I don't agree with you that there is an absolute way in which it comes in every trial. There's certainly a way that it can.
So I misspoke then. The Constitution doesn't guarantee anything comes in. The Constitution says if you follow the rules of evidence, that if you're able to show what you need to show, then it comes in. So if I said there's an absolute way to get it in, I misspoke. What I meant to say, to the extent I was ambiguous, is that there is a process that you can go through where if you jump through all the constitutional hurdles, it will come in. If you don't jump through the constitutional hurdles, it doesn't come in. It shouldn't come in. And I can remember a case I had years ago where I was trying a case and the prosecutor, for the most part, didn't know the rules of evidence. And I was able to keep everything out. And I don't think, and so my client I was found not guilty. And some stuff maybe should have come in, except for the state didn't know how to get it in. That's not my problem, right? The Constitution says that the state has to prove every element of the offense beyond a reasonable doubt for it to come in. And if the state can't do that, then it doesn't come in. And so my concern is that District Attorney's Office wants to change a law to make the standard lower, which goes against constitutional principles, so that they can guarantee that some evidence comes in. That's just my opinion.
I understand, and I certainly respect your opinion. Going back to the intention of Representative Cook's bill, specifically speaks to the reason that this body has already passed 3837 into law, taking into consideration those same constitutional principles that you're speaking about, Representative Jones. 404 existed and the Constitution existed when this body looked at and considered ever creating 3837 in the Code of Criminal Procedure. And because of the nature of these types of offenses and the fact that these perpetrators commit the same types of crimes over and over again, this body said that it believed that this specifically just evidence as it relates to extraneous sexual acts, not every bad act a defendant has ever committed, that should be able to come in guilt innocence for the three reasons that are outlined specifically by this body in the code. And so because what we see in our practice is that the nature of those perpetrators and the nature of those offenses is they're committed against children are committed in the same way against adults. We believe that the evidence of extraneous offenses or acts, that exception that this body gave us for 3837 should be expanded to adult victims of sexual assault and aggravated sexual assault.
I wasn't on this body when it was passed, and we have so many people coming up here all the time. They passed the law, they realized something was wrong with it, they came back to fix it. And we have hundreds of years of precedent in this country, these United States of America, that understand that when someone is being charged with a crime, the most precious right that we have is the right to control our bodies and our freedom. And that the bar is set high. It's the highest standard. It's not preponderance. It's not clear and convincing. It's beyond a reasonable doubt for a reason. And the second we allow the government to lower the standard for its stuff, beware. And I know there are some people that lie more convincingly than some people tell the truth. And as I said before, there's already mechanisms with the balancing test to get that kind of evidence is if you jump through those. But I understand why we might make an exception for children, because they are not similarly situated. They are not the same as adults. And if, now, again, and I'm going to say this, if the law says, which it does, that if you're actually convicted of a bunch of rapes, right? You've gone to prison, you've got a record, and you're charged with a rape again. If you go to trial, you exercise your Fifth Amendment right to remain silent, and so you don't testify, your lawyer doesn't ask any questions of anyone about your character for goodness or anything. When we know that they have a conviction and we can't use it, and at least we know that that was vetted. Like, at least we know there was a guilty plea or a jury found them guilty. Why would we allow less with a hearing and not a trial or a plea? I'm just really struggling with that.
And I completely understand your concerns. But, again, given that the hearing outside the presence of the jury, the 30 days notice is what this body determined, and I understand you weren't here when that happened, but the legislative body of Texas determined that was sufficient in order for this evidence to be allowed in for child cases. We believe that would be sufficient in a similar circumstance for adult cases.
I'm sorry.
But I don't believe that I don't believe that we're necessarily going to see eye to eye to that on that today, and that's okay.
But I also think there may be a confrontation clause issue as well. Because if I don't testify as a criminal defendant, I exercise my right to remain silent, which is a pillar of the Constitution. I literally can't get up if that evidence comes in because you show this. I literally have no way of confronting witnesses against me. So you're forcing me.
No, ma'am, you do. Your defense attorney has the ability to cross-examine the witness both in the hearing and then if that is admitted at trial, in front of the jury. That is facing the witnesses against you.
And I'm going to have to respectfully disagree, but that's fine. Reasonable minds can disagree. I've got a problem with the constitutional implications and lowering the standard for the government, because if the government can't reach the highest standard, then it shouldn't be coming in. That's all.
Mr. Cook, you have a question?
Yes, sir. So earlier, Ms. Jones was talking about freedoms in the United States, and she was talking about controlling our body, and I believe she was referring to the body of the defendant. Is that how you understood the question?
Yes, sir, that's how I understood
Do you think
that.
that same control goes to the victim? Do you think the victim has control of their own bodies when they're being raped?
They have no control over their own bodies when they're being raped. That's being taken from them in that
So
moment.
Article 3837 gives that protection to children, correct?
It does, yes.
And so what we're asking is, and you've heard testimony today that, and I know it's categorical by saying this, but in most instances, we're talking about women that are being raped, correct?
In most instances, yes,
And
sir.
so we're trying to protect women just as children are already being protected by Article 38.37. Is that correct?
That's correct.
Okay.
We're trying to give the state an additional tool to hold these types of perpetrators accountable for the violence that they commit in our communities.
All right. And then if we go to, okay, you do have the code in front of you. Ms. Jones is talking to you about the rules in 404 and 405, and we've talked about statutory interpretation today, where some statutes, depending on how it's written, can be more narrow or they can be broad. And Representative Jones just talked about that, her having that concern today, right, throughout today.
Yes.
Okay. And so if we look at paragraph B of the bill, page 2, line 9, it says notwithstanding. We all know what that means, notwithstanding. Some rules 408 and 405, Texas Rules of Evidence, evidence of other crimes, wrongs, or acts committed by the defendant against the child. Okay, so it's against the child who is the victim. So if we're marking that out, and earlier she had concerns that we were marking the child out, we're marking it out because we're saying it applies to all people, correct, not just children.
That's correct. That would be a cleanup for Legislative Council.
Right. But as it's drafted right now, would a judge most likely interpret this protection under rules 404 and 405 to only be a protection for a child, because it specifically talks about a child, not a person?
Oh, that's correct. Yes, this only applies to children right now.
So earlier she was kept talking about, the opportunity to get this evidence in. You as a prosecutor should be able to get this evidence in. Wasn't it through using rules 404 and 405? Is that what she was referring to?
Yes.
Okay.
Yes.
All right. So if you look at the language of the current statute, it's that instance where it's talking about foregoing, where it says notwithstanding rules 404 and 405, that protection, as I would say it is, only applies in a case against a child. Is that correct?
That is correct.
Okay, thank you.
Okay, anything, Mr. Little? I'm sorry.
I'll defer to Representative Jones. I've got
Representative
some more
Jones.
questions.
Yes, so to the extent I was ambiguous, what I said was, so I can tell you what I said and what I meant, is that this should not be opened up to all people. It should stay with children because they're a special class. That's the first thing. And so I was referring to the child part being stricken because it's stricken. It is taking it from just children to adults. And even though most, and I don't know if it's true or not, maybe it is, most of the people that are victims of this are women. That may be true. But men deserve to be protected too. I mean, it's not like so I don't understand that argument. But this talks about 404 and 405, but we also have 403 where we do the balancing test. So again, I just don't like to chip away at the Constitution when really bad stuff happens. And I just don't, because when is it gonna stop? And God forbid that the government targets you. And they believe wholeheartedly in good faith that you did something and you didn't. We don't want the government to have a lower standard. And when I was talking about the body, I wasn't talking about not being able to, the woman not being able to protect her body because she was raped, because I've been raped, okay, more than one occasion, right? But I'm trying to compartmentalize for just all people. I'm talking about if you're going to take away my liberty and put my body in prison for however long, we need to uphold the standards of the Constitution, is what I'm saying. So I'm not trying to minimize women. I'm not trying to minimize men. I think children are different than both men, well, adult men and women, and we shouldn't be creating exceptions to the Constitution for laws that have been well established for centuries. And although I wasn't here in 2013 when I think this bill first was passed, there's probably a reason why, and I haven't looked at the purpose of it, why they carved out kids, because they were, kids are more vulnerable than adults. So to the extent anybody had any confusion about what I meant, and I'm passionate about, I believe in the Constitution with the amendments, because without the amendments, I wasn't a person, right? But we founded a whole country because we wanted to make sure that the government, with all of its resources, couldn't crush the little guy. And I think that this is a lower standard that allows the government to crush the little guy. And that's all I'm saying.
I understand your concern.
Mr. Little has a question.
Yeah, just a logistical question. Let's say Representative Cook's bill passes, signed into law. Does your office have a Brady obligation with regard to the extraneous offenses? She's nodding yes. She's with you. I'm not so sure, but go ahead.
Well, so, I mean, specifically when you talk about a Brady obligation, that would be to disclose any evidence that is exculpatory. And so if a victim of a crime, an extraneous victim of this victim tells us anything that is exculpatory, we absolutely have an obligation under Brady to disclose that information. Now, under 3914, which is the Texas legislature's discovery law, for criminal cases, our obligations as prosecutors is much more broad than what is required of us under Brady versus Maryland. And so in
Talking about the Michael Morton Act.
Yes, sir. And so, sorry, we refer to it as 3914 because
that's I mean,
the Code of Criminal
yeah,
Procedure.
I
My
don't remember.
apologies. Yes, under Michael Morton. And so in our office, in Tarrant County, long before the Michael Morton Act passed, had what we called an open file policy. Anything I have, they have. The only thing that the defense attorney does not have is what is considered my work product. And then we do not, because under 3915, this body told us we cannot give copies of child forensic interviews to defense attorneys. They have to access those through a secure system in our office. But everything I have, they have. So any notes from meeting with an extraneous victim that I have taken, that's one, if I intend to use that evidence, would be disclosed under this requirement in a notice in 3837, but those notes are also going to be typed up, uploaded, and opened to the defense attorney immediately.
What about things that the extraneous witness tells you that you don't put in a note?
I'm,
Do you have to disclose that? Yeah.
yes,
Okay.
yes.
Um,
And so to that point, I'm like something that wouldn't go in a note, we'd take, I mean, the only thing I don't take down is small talk conversation that at the beginning, what'd you do today before you got here? You know, things that you just have general conversation with people as you're walking back to the meeting room, how was the drive? I don't disclose that sort of information, but anything of substance that occurs in the meeting is taken down and disclosed.
okay, that's helpful. Thank you.
Okay. Any other questions? Okay, Ms. Jones.
One final one, you're taking notes. Some things are obviously exculpatory. Sometimes witnesses are talking and it leads you to something else, right? So you heard it and you use that as an investigative tool to go find something else. Do you put all of that there so that the defense lawyer has the opportunity to maybe go down those trails?
Again, if it is substantive information that's been given to us in a meeting, that's going to be taken down, uploaded, disclosed to the defense attorney. And if, you know, they give us an additional witness's name and contact information, and we, you know, they're going to have that, and we go talk to that person, additional notes are going to be taken, and that's going to be disclosed. Now, I'm not going to disclose, called that person 9 times and they didn't call me back, but they would have that person's name and contact information the same as I did.
So here's my experience. I might have trial set for Monday, right? So I start preparing 2 weeks, a month, depending on how complex the case is. On Friday, after business hours, I get something from the state saying, oh, by the way, this just happened to come up. Totally upends my defense. Now I can't prepare like I would have prepared, and I'm trying to track down people or track down stuff based on information I got at the last minute. And most times the judge is like, counsel, that's enough time, when it's really not enough time to be able to vet anything. So I'm,
Okay.
okay, we can talk like offline. I'm just really struggling.
Okay, we appreciate you being here. Thank you very much.
Thank you so much.
We have Amy Derrick here. It's your. Once again, we apologize for the late hour.
Hey,
that you
no
went.
worries. I've done it before. Good afternoon. My name is Amy Derrick, and I'm here representing the Dallas County District Attorney's Office, and I am in support of this bill. I am the chief of the Sexual Assault, Crimes Against Children, Human Trafficking, and Cold Case Violent Crimes units of the Dallas County District Attorney's Office. I have been exclusively prosecuting sexual assault cases of both adults and children for over 15 years, almost 20, 21 years as a prosecutor this year. And I appreciate the opportunity to be here. As I've mentioned, I've been on the front lines of prosecution of these cases for almost 20 years. I'm also responsible for the creation and the supervision of our office's decade-long project to test previously untested sexual assault kits, and then to follow up on the results of those kits, both with investigation and prosecution where it's appropriate. What we have learned from our project, and as we've all heard from comments all day long today, is that sexual offenders are serial offenders. Our own statistics from our sexual assault kit project report that we have 560 offenders that account for the sexual assault of 949 victims. This statistic shows the serial nature of sexual assault perpetrators. It should also be noted that our sexual assault kit initiative project primarily focuses on adult victim cases. So those 949 victims are primarily adults. Additionally, there is also a body of research out of Case Western Reserve University up in Cleveland, Ohio, that addresses and agrees with this very same conclusion. And as we have also heard today, as we've talked about registration requirements, our own sex offender registration laws contemplate the idea that sexual offenders are going to reoffend, or they're at least a danger to that, which is why we want people to be on notice and on warning, and that's why we put them on a list. This is an incredibly important tool in this bill because it aids prosecutors in holding the most violent serial offenders accountable. Often the victims of sexual assault are members of what was traditionally considered to not be credible by both police and prosecutors. They are often homeless, they are often addicts, sex workers, mentally ill, and even intoxicated victims. Under this bill, no longer will a prosecutor have to worry and wonder if the 12 in the box will find a victim to not be credible due to those factors, while we sit knowing only 3 feet away from that perpetrator that they have done this time and time again in exactly the same way, in exactly the same manner to other victims. That the perpetrator's modus operandi, state of mind, their plans, their schemes, is to target and assault vulnerable victims. And now the jury will know it too if this bill is passed. This bill works to expand, as you've already heard, what is already afforded to child victims, and it provides equal protection to adult survivors of sexual assault. Adult survivors struggle to tell the story of what happened to them just the same as children struggle. All struggle to enter that courtroom and tell the most horrific event and recount intimate details in a room full of strangers who are tasked with questioning their credibility and lodging judgment against them. All victims experience the trauma of sexual assault. They run through the same roller coaster of emotions: shame, guilt, fear, embarrassment, fear of not being believed, fear of their offender. This bill provides prosecutors with the same tools for prosecution, no matter the age or the circumstances of that victim. It recognizes equal importance in expanding the rules for all victims, and it also considers that perpetrators offend in the same manner, no matter the age or the circumstance of a victim.
Any questions for Ms. Derrick? Mr. Little?
Ms. Derrick, thank you so much for your testimony. You're a hyper-experienced prosecutor in this type of crime, so I've got some questions for you. All of your plan and MO evidence, including extraneous offenses, is already admissible as part of a plan or an MO under 404, isn't it?
It is if the judge allows it to come in. And I can tell you that that is a crapshoot of the dice every single time.
That's true in all my cases too, if I'm trying to show other bad acts in a civil case. But let me ask for like a hyper-specific question, and I'll ask you, just give me your best honest answer. How many cases on sexual assault have you lost because you didn't get in extraneous act evidence? You're like, I would have won that case if I could have gotten in the other 3 or 4 offenses.
Plenty. I can tell you plenty. I mean, I can't give you a number because I've done so many, but I mean,
you've probably done thousands of them,
yeah,
right?
I mean, because oftentimes we're talking about, we've heard about, children are vulnerable, they're a special class of victim, right? Except that they're exactly the same class of victim that we see with adults, as I was mentioning. Oftentimes our victims on these types of cases are specifically targeted because the perpetrators hope that they're not going to be believed because they fall into one of our marginalized populations. So when I talk about victims who are mentally ill or they're on the streets, they're the perfect crime of opportunity, right? And we also know that sexual offenses are often opportunistic. I mean, children, they're opportunistic. They are there, they're easy to get to, and it's easy to get away with it. Same with these same populations of adults that we run into time and time again. We've talked about victims who are intoxicated. They are a perfect crime of opportunity because they're unable to fight back, flee. Instead, they freeze, or they don't even know what's happening to them because they're unconscious or incapacitated. And so what really we run into here is we have people, especially even, one of the benefits we've had of our sexual assault kit initiative project is that we are prosecuting cases that happened 5, 10, even 20 years ago, with victims who are still in the same life space that they were in back then when the police didn't believe them or when prosecutors didn't believe them. And they walk into court and oftentimes they're still in that same space. And we're hoping that those people in the box are going to be able to get past that and see the
Sure,
truth.
I understand that
Yeah.
situation. And in my experience with 404, it is a crapshoot. I mean, based on the judge is able to use his or her discretion to determine whether a true plan or MO exists that's going to give rise to using that evidence. But if Representative Cook's bill passes and becomes law, my understanding is that the judge won't have the discretion to make that decision anymore in those types of cases. It just comes in, period, right?
Yes. Mm-hmm.
And I'm just not sure how I feel yet about taking that decision out of a judge's hands, because the more remote in terms of time and method of, or the more remote in terms of time, methodology, nature of the offense that the extraneous offense is, the less likely it is to be part of a plan or some type of MO. And so do you think that the amount of time that passes between those extraneous offenses and the subject offense of the trial matters? Do you think that the type of victim matters? I mean, what do you think about those issues?
Yeah, so I don't think it matters, because we're not only just talking about the modus operandi, but we're also talking about the nature of the perpetrator. And that's what we run into when we look in Section 2 of this bill, too, is that we're talking about the nature of the perpetrator. So if they have raped someone 20 years ago, that's still in their nature that they've raped someone today. And that's kind of what our statistics show, is that they are serial offenders. And we've already extended this to children already. We contemplated this already, that it is in their nature to offend and reoffend. And we're just saying what we know now. We've done so much research, and frankly, it's not something that's unique to Texas. It's been across this entire country. We have been so slow to catch up when it comes to recognizing that adults on these types of cases, like the adult victim sexual assaults, really aren't that different from the child ones.
I can understand.
Are the same.
I can understand that perspective. I'd like to ask you, I'd like to pose the same question to you that I posed to ADA Lawrence, which is, in your view, does a defendant get to put on controverting character evidence that my last 10 girlfriends or my last 10 boyfriends said I was a perfect gentleman or lady?
Mm-hmm. So, I actually run into that in child abuse cases all the time. So we will have a child victim come in and testify, and they'll have siblings, and the defense will try to put on evidence that he only raped this one, but look, he didn't rape these other 3, so he must not be guilty of the one. I mean, we run into that already. And just because you choose to sexually assault one person and not someone else does not mean that you're innocent of the one that
His
you did
question was
sexually
whether
assault.
it comes in or not.
Yeah, does that controverting evidence come in or not? Because normally that's improper bolstering, right?
It is, yeah.
And so, like, you've got a gun. I'm going to use the extraneous offenses. Does the defendant have a gun to say, well, I've got evidence of my character that's extraneous to the offense that I was introduced to? Do they get to use that?
It generally does not come in.
I didn't think so.
Yeah.
Okay.
Ms. Jones has a question.
So I was trying to figure out the legislative intent of 3837. And here's what I learned. The primary intent was to acknowledge the unique nature of sexual offenses against children, including patterns of behavior and grooming. To address the low reporting and conviction rates in child sexual abuse cases, where it's often one child's word against an adult's. And also what I know from like young kids, they can't explain stuff, right? When they get older, when they were a younger kid, they didn't know what it was, but then they got older and they learned, oh, this was bad. It shouldn't have happened. To allow the jury to hear about prior similar acts to support the child's credibility and establish the defendant's propensity, which is usually excluded under Rule 404B. To create an exception to the traditional bar on character evidence for a very narrow and specific class of cases, sex crimes against minors. And why the adults were left out, because remember, I was just sort of thinking through that. Adults were excluded for several reasons tied to due process concerns and evidentiary fairness. Number one, higher risk of unfair prejudice. Adult complainants are presumed to have more credibility in court, and allowing prior bad acts to show a defendant's propensity in adult cases was seen as overly prejudicial. Number two, preservation of the general rule of 404B, which is what we were talking about before. The Texas legislature carved out a narrow exception to this rule for child victims, but left the traditional rules in place for adult cases. Number three, scientific and legislative focus on child victimization. In 2013, legislative hearings included testimony from child protection advocates, prosecutors, and psychologists who emphasized the challenges children face in disclosing abuse and testifying. And I'll say that even as a kid who was brutalized by my uncle when I was 3 and he was 6'7", so use your imagination. So obviously there are difficulties there. Legislators believe that sexual predators who target children often display repeated behavior, making it essential for juries to consider those patterns. And actually there's a quote from then Senator Joan Huffman, a former prosecutor, who actually, when I was a baby lawyer, she was practicing, saying these types of predators are often repeat offenders and children are often too scared to tell if there's a pattern the jury deserves to know, right? So that's why they excluded adults. And I don't think that changed. And when Representative Little asked you about, do you think how remote it was, the statute of limitations, there's a reason why you can only use things that are proximate, right? Because if I'm trying to go, like I've had cases where my client said, Ms. Jones, I didn't do that. The longer ago it happened, the harder it is to find witnesses. Witnesses' recollections are not always accurate, which is why they want for you, why there's statute of limitations, so that everything you need to try to be able to prove your case, it's there, or to create reasonable doubt. So I went and did research on that just really quickly because it was important for me. And I think the things that held in 2013 are the same because children are different. And again, I just have the same concerns.
Yeah. And I'll agree with you and also push back and just reiterate what I mentioned just a second ago to Representative Little, which is we just know more now than we even knew then. The beauty of these sexual assault kit initiative projects that have been happening all over the country is that all sorts of research groups at universities all over the country have had a control group of cases to do all kinds of research studies and to learn. And what we have figured out is that the perpetrators on adults really aren't that different from children, that the struggles that victims have, even as adults, really isn't that different from children. It's just in different ways, but it is just as hard. Their credibility is just judged just as hard. It is just as difficult to explain what happened to them. And so that's why here we are. You know, I said we're slow to catch up. This is what we're trying to do, is catch up, because we're trying to expand the equal protections to adults on these same cases, because we have been slow to do so for so long.
Okay, and let me see if there's any other questions. Oh, Mr. Cook.
Thank you, Chairman. Just have a couple questions. I'm the layman on this dais. So just so I understand it correctly, we're basically just taking if this bill passes, previously you could only bring forward extraneous, is that right, extraneous charges or activity in child cases. Now we're making it across the board where anyone accused of sexual assault can bring that forward for previous, that's my question, is it previous convictions, or can it be any bad behavior can be brought forward?
It's any bad sexual behavior. So sexual offense.
But
it already applies to children.
Yeah.
We're just eliminating the child part.
And when you say offense, does that mean they were convicted in a court of law?
Not
bring that forward?
necessarily.
So it
No.
could be an accusation that could be brought forward?
It could, but we
Okay.
do have to provide notice, and we also have to be able to prove it beyond a reasonable doubt.
Okay, but, so there wouldn't be due process of something they were being accused of from prior, is what we're saying on that.
It could be or could not be. I
Okay,
mean, it
and
really
then-
just depends on what the allegation is, right?
Okay,
And where
and-
it's been or not.
Yeah, and then to her point, there's no statute of limitations where somebody could say, hey, 20 years ago, somebody possibly did this, and then that's what they could be judged on in the court hearing for this current charge that they're facing. Is that correct?
That's correct.
Okay, all right,
Yes.
thank you, appreciate it.
Okay, anything else, Mr. Cook?
I just had a question. What was the source that you quoted? You offered it as legislative intent, but then you started reading a bunch of stuff. It didn't sound like it was from like the Legislative Resource Library. I mean, it just sounded like a seminar or...
I mean, I have some Case Western Reserve University, Science Daily, The Daily. I mean, it's all cited.
But it's just opinions. It's not, you said it was being offered for legislative intent.
When we file bills, there's legislative intent, so I can go look at things to see what the legislative intent was. Like
Well, how do you, yeah, okay. I mean, I get the Senator Huffman comment, but that didn't deal with this bill. That part of it didn't deal with this bill. I mean,
It did. It said that the reason that, from the legislative record, so it's in the legislative record in the state, where it said, Senator Huffman said, these types of predators are often repeat offenders, and children are often too scared to tell. If there's a pattern, the jury deserves to know. So it's from the Texas, it's from the legislative record.
right, that's the only part of everything you read. That's the only part.
it's from
The rest of it were someone's opinions, and that's what I was asking. Whose opinions were they? I mean, only legislative intent I heard, even remotely close, was Senator Huffman's.
Well, it's like if I read a synopsis, I read it, and I'm not gonna like read out the whole thing.
Right, but that doesn't mean legislative intent is what a legislator intended when he passed a bill. He or
No,
she.
I understand that. That's what I wanted to know, like why were kids put in and why were adults left out? And there were just factors in the legislative record that they said were the factors of why they changed it for children and left out adults. So it's in the legislative record.
And are you aware of any constitutional challenges to Article 38, 37?
No.
You've not seen any of that or heard any of
No,
that?
we have
All right.
not.
Thank you, Chairman.
Turn it on. It's off.
Turn it on, so because nobody can hear.
Oh, I'm sorry.
Whoever's watching on TV won't be able to hear.
Oh, I'm sorry. I didn't even know.
So,
My apologies. Do you need me to repeat it? It's in the text, it's in the legislative
no,
record.
no. But I think we get, that these are two different circumstances, and just the question of whether you want the same rules to apply to both is where we are. Anything else, members? Okay. Thank you for
No.
being here.
Thank you.
Appreciate it. Anyone else here to testify for, against, or on House Bill 1977? If not, Mr. Cook, closing time. Okay?
All right, I'll be brief. I know we're ready to conclude the hearing kind of early today for a criminal jurisprudence hearing. It'll be done around 5 o'clock, so. But,
Enjoy your evening.
Yeah, so the only constitutional issue that I see here is equal protection under the law. And I think that that's what this committee should look at when making a determination as to whether or not Article 38.37 of the Code of Criminal Procedure should or should not be amended. I don't really have a whole lot more than that to say, but in my opinion, under equal protection argument, all people, including specifically women in a sexual assault, I mean, you heard from many young ladies today, and so if a stepfather has been, sexually assaulting a child for years, I just can't imagine anyone would not want that to be known in the prosecution of a criminal case. So
Mr. Wood?
I'll be glad to answer any questions.
Yeah, so, I know, again, I'm not terribly familiar with this part of the code.
I'm sorry, I didn't hear you.
I'm not terribly familiar with this part of the code, but I know like in like the family violence code, there is a separate charge called a continuous family violence that is proven up in a different way. I don't know if that would work in this part of the code, or you say like if there is a continuous sexual abuse, that pattern, that this was a part of that pattern of continuous sexual abuse. So like what you would argue on the family law case is that like this act of violence that was actually documented was a part of a continuous set of violent acts. I think that's a different thing than and like I'm trying to, and I see your side, I see there's everyone's side is like, well, I mean, but what if the extraneous offense, the extraneous act that you want to bring in was like somebody made an accusation 20 years ago, that accusation was never borne out, definitely never convicted. I mean, you know, and there could be even be an accusation that you didn't even know about until now, that they asked around, somebody popped up and said, yeah, 20 years ago, this happened. I'm like,
So what if you had a traveling pastor molesting a 14-year-old child? I want to give you a scenario.
Yeah.
Molesting a 14-year-old child over a 5-year period.
Yep.
So if you're against this bill, you would. I'm not saying you, Gene. I'm just saying, if you're against this bill, you would be against evidence that occurred before the 18th birthday. While she was a child, we're going to protect. We're going to exclude it. But now, once she reached 18, it's fair game. It's no longer protected. And so and I know that's a case. It's in the news now.
Yeah.
And so I'm just saying that's the type of behavior. And so I think what the state is wanting to do is be able to at least bring that type of information before a jury in deciding guilt and innocence. And I think it's very relevant. I would want to know as a juror, I would want to know as a policymaker, I'd want to know as a parent, as a friend, that those protections are there for all people.
and I don't think even the different sides, I don't think that you're in different pages. I think everyone's on the same page. I think people want these kind of cases.
Representative Jones and I are on a different page.
Well, no, wait. I think we say that, but like, we all want these cases prosecuted. I think the question is, like, you want these cases prosecuted, but you don't want to catch people and catch situations that you did not mean to catch, right? And what if that looks like, I'm not really sure. I think there's ways to work this out. I think you could have provisions in there that says, like, look, you can offer this evidence, the judge will have a hearing on it, and there could be like a 403 sort of like a weighing of like, hey, is this more prejudicial than it's valuable? Because you say like, if you say like, that this person is alleged to have assaulted multiple children, but the allegations in the past were like allegations against adults. Maybe you say like, well, I don't know. I mean, you get, again, I don't defend or prosecute like these type of cases. But I'm just saying like maybe there's a way that the middle ground could be like you could work out a mechanism where there's some kind of safeguard, right? Because I think that's what they want, is that just that the situations that we don't intend to include get excluded, and the thing that we do intend to include get included, right? Build a filter.
Thank you.
Ms. Jones, yeah. And Joe, let me ask you one question. Do you think it would ever be appropriate to bring in evidence like we've been talking about under some limited circumstances or not?
Yes, but that happens already.
Okay.
That already happens, right? And I remember a case that I had where I had a man who was accused of raping his girlfriend's daughter. And I mean, CPS got involved, just all these things. And at the end of the story, after he's been accused of something that if he did it, it's bad, he needs to be put under the jail, right? But this teenager who didn't like that before he started dating her mom, she and her brother had no rules. Come in when they want, have people spend the night and stuff. Interestingly, she heard from her friend whose father actually was raping her. So when the police got called, obviously he got arrested and they made him leave the house. Well, she wanted her mom's boyfriend out of the house because he was like, no, you're a little girl, you have a curfew, you're gonna study when you get home from school, you can't have people spending the night. And it was just the Dickens, and those are the kinds, at least that was headed to trial, and by the grace of God, I was able to exonerate him. But when you have stuff, especially stuff that's really old, right? Where are the people? Like, how do we investigate that? I actually don't even think 30 days is enough time to investigate that. Somebody's phone number may have changed. They may have moved to another state. I know with even with my forensic experts, I have to link up with them if I'm trying to track cell phone data or something. If I have to subpoena it from the AT&T, that takes forever. They're going to have lawyers trying to stop me from getting that information. People's memories fail. And so the more remote it is, the more difficult it is. And I don't think that you can prove something, I mean, I guess in very rare situations, beyond a reasonable doubt in a hearing. And so it's just, as a practitioner who tries cases, that's just really hard. And the person that you're describing is bad. I would agree with you, right? That person is bad. But I struggle with changing something that's been established in the Constitution for that when there's already a mechanism under 403 to get that exact evidence in. You just have to jump through those hoops. And it scares me when a prosecutor says, I want to be able to guarantee bad evidence in if I think they're bad enough. I just think that there needs to be, and it needs to be at a high standard. So, and so Rep. Cook or Chair Cook, this isn't like, I actually do think we agree. I just happen to think that we need to have a bill that's more in line with constitutionally established practices, and we're not enemies. I want bad people locked up for a variety of reasons. I just want us to make sure we give them due process in their constitutional rights. That's it.
Why don't y'all visit about this and
Sure.
see if there's any way
Okay.
I understand. I would just remind, and I know this is stating the obvious here, but I think what we've already heard today and prior committee hearings, and I guarantee we'll continue to hear as people come up and they talk about expunctions or enhancements, they always refer to two classes of cases that are the ones that we worry about the most. The ones that we're not going to get an expunction on are what? Sexual assault, sexual cases and violent cases. Those are the types of cases. That's what we're talking about here. I just want to remind everybody that we're talking about sexual assault and aggravated sexual assault. And I definitely respect the Constitution and would do everything I can do to uphold it. And specifically that you're innocent until proven guilty, not the other way around, which I know is what you're leaning in on, and I respect that and appreciate that and agree with that. But I guess I have a lot of confidence in prosecutors, and I know you're a defense attorney, so you probably have less, and you have reason for that. You've been doing it for 30 years, and I understand that. But we just stood here and listened to an expert, and she tells us that they need this in their toolbox in order to get sexual offenders off the streets. And that's why we're here, is to make sure that they have the tools that they need in order to get violent sexual offenders off the streets. And so
There may
that's
be
the
a
purpose of
way
the bill.
to do that. I mean, a way to kind of deal with, yeah, well, good. You're both reasonable people, so. Okay, anything else, members? Well, we
Thanks, Chairman.
appreciate it, Mr. Cook, and we appreciate the witnesses being here. I think we all learned a lot about the issues. So
I agree, and I did as well. Thank you, Chairman, and I close.
And so if there's no objection, the chair will leave 1977 pending, House Bill 1977. And I think that is our last bill. So appreciate everyone being here today. And if there's no further business before the committee will stand adjourned pending call of the chair. Thank